Hello and welcome to another episode of A Question of Law. Now, this is Citi TV's legal education program. Now, on this show, we seek to break down the law as it regards, various aspects of our lives. Now, you know that in recent times, there's so many different conversations that are happening. The Supreme Court, politics, medical issues, hospitals, and so on and so forth. And this is why we have a question of law, so that our legal panel will help us to understand better why some of the decisions that are taken and what happens and what it means and all of those things. Well, we're going to be having a conversation today, so we'll take a quick break. When I'm back, I'll introduce my guest to you and we'll get right into the conversation for today. All right, welcome back from that break. Now, let me introduce my guest to you. Today's conversation, by the way, is about medical negligence. Yes, a lot of times we've had issues in the last few years, at least that have been in the media space. There have been people that have gone to hospitals, the issue of no bed, we call it the no bed syndrome, all kinds of different things. And people have complained in different hospitals, different facilities, that the doctors didn't take care, the nurses did this, and so on and so forth. Well, medical negligence is a conversation for today, and my guests are here. They're both private legal practitioners. We have Albert Kwashiga, who happens also to be a law lecturer with the UPSA School of Law, and we also have Kwesi Kelly Delata, who is also a private legal practitioner. Gentlemen, you are welcome.
Thank you.
It's been a minute.
Well, it's been like 2 minutes.
2 minutes.
It's good to see you again.
Yeah, definitely it's good to see you too.
Yeah,
Absolutely. Right.
Always delighted to be here.
Fantastic. Well, let's get right into it. Medical negligence. First of all, what is it? I mean, because sometimes we can say it and there's the English meaning of it, and then there's also the legal meaning. So what's medical negligence?
Okay, so am I supposed to go?
Yeah, why not?
Okay, so I don't know from the nature of the question. I don't know if I'm required to give a definition, because if I were required to do so, I can't provide a definition for medical negligence.
Okay,
but I can explain what exactly it should cover. Negligence can rear its head in many aspects of our lives, actually. And in the medical space, that's just one space where negligence can arise. But negligence itself is a body of legal principles which, require that in our relationship with people, we have a certain duty towards them.
Okay. And
we must, at all times, strive not to breach that duty. And if we're to breach the duty, and injury is suffered, then some compensation must follow. So generally, if you talk about negligence, it requires that there's a duty owed by one person to the other, and that duty must be performed according to a certain standard. And once you fall short of the standard, and there is some form of injury, then the person who suffers the injury has, the right to seek compensation for the injury that he or she has suffered in the circumstances. And so there can be medical negligence. And so medical negligence would cover situations where all health practitioners, those who work in the hospitals, or whether public or private, who deal with patients, are required to, have a certain duty towards them. And I have to say that in certain situations, the duty you owe to the other person is a matter of law. So it's a duty imposed by law. So for instance, medical practitioners owe a duty to their patients, to be careful when they advise them, when they treat them, and others. If they do not comply to that standard, and the standard is actually what is expected of a reasonably skilled person. So if you have been trained as a doctor or a nurse, there are certain things expected of you, and you are required in your dealing with the patients to bring to the fullest extent that standard. If you fall short of that and there's an injury, you could suffer consequences.
Kelly.
Yeah, just to add a bit to that, and I'm happy that you're not insisting on us having to give you any legal definitions. I mean, in law, we say that words are simply inadequate to describe legal phenomena or normative phenomena. And so the best to do is to actually describe. And he's done a fantastic job of giving us an idea what negligence is. Except that I want to zero in on what medical negligence is. In fact, if we talk about medical negligence, we're talking about a situation where the conduct of a health professional, let's say a doctor, let's say a nurse, his act or mission falls below a certain standard.
Okay.
Which is to say that there are standards which are prevailing in the medical profession relative to the conduct of health professionals. So if that conduct or mission falls below the acceptable standard, then we call that medical negligence.
Okay.
Now, sometimes such negligence may not necessarily lead to injury to a patient, and so therefore remain just what it is, it's just negligence.
Okay.
But sometimes such negligence can lead to injury to persons. It can lead to loss of limb, it can lead to death in the most bizarre circumstances.
Capacitation.
Then at that point, we're talking about medical malpractice.
Okay.
So for medical negligence to coalesce into actionable wrong, it ought to move from just simply medical negligence to medical malpractice. And I want to give you an example. Let's say that you go to a hospital and the doctor prescribes the wrong medicine and you take it. Nothing happens to you. There's no injury. The condition you took to hospital that doesn't exacerbate, if you like. But you notice later from conversations with another medical doctor, oh, they shouldn't have given you this medicine.
Okay.
And then they examine you and realize that even though it was misdiagnosed, you got the wrong medicine, but you didn't suffer any injury. At that point, remain just medical negligence.
Okay.
But if you take that medicine and it leads to your injury, deteriorating, or you suffer some other incidental medical condition, then at that point we say this is medical malpractice.
Okay.
Yeah, that's just what I want to add to.
Yeah.
Okay.
Are there types of medical negligence? Would you grade them? Would you differentiate between them? Are there types?
Yeah, so Kweku, we don't have types of medical negligence.
Okay.
I mean, negligence is negligence. And I say that because the legal metric which is required for a claimant to prove in order to establish actionable negligence is the same across board. So first and foremost, the claimant has to prove that the doctor or medical facility owes to him or her a duty to be careful. And there's hardly any question in law about the duty relationship between a medical doctor and a patient. A long line of cases have established that a medical doctor owes to his patient a duty to be careful. Then the next one will be whether or not the doctor is in breach of that duty. And this is where we say it's a function of standards. So we say the action or omission of the medical doctor, does it fall below the required standards of the profession? And that is important because globally, there are standards of medical care, relative medical procedure, relative to different kinds of treatments. So if a doctor falls below that standard, it's proof that they've been in breach of the duty of care which they owe to a patient. It can also be a function of, if you like, autobiographical standards, because different countries, they have different standards for medical practice. So we have the Ghana Dental and Medical Council, they are called. They may have the standard protocols for procedures relative to different kinds of treatment and so on. So if a medical doctor's conduct or mission falls below those standards, then we say that they're in breach of the duty of care which they owe to a patient. But as I've said to you, a medical doctor can be in breach of the duty of care which he owes to a patient. But that does not necessarily mean that they have to pay compensation. Or that's to say that there's conclusive, actionable negligence. For a breach of duty of care to result in actionable negligence, they ought to be proved that that breach has resulted in injury to the patient. If there's no injury to the patient, it remains what it is, just medical negligence for which a medical doctor will not be compared to pay compensation.
An interesting question comes to my mind. I'm looking at a situation where, let's say, in the process of a surgery, you're suturing up, a surgeon is suturing up a patient, and you leave behind, let's say, a scalpel or something, you know, inside, or maybe not even something as sharp as that, but maybe, I don't know, something is left inside, right? Now, it becomes increasingly uncomfortable for the patient, and only for them to go for an x-ray and they discover that there's something in there, right? Now, even though the patient may not necessarily be injured, can the patient in that case then sue for medical negligence?
Absolutely, Kweku. This is a typical case of medical malpractice. If the patient suffers any form of irritation, that would be classified as some kind of injury suffered by the patient. And so we have then a situation where medical negligence doesn't remain medical negligence, but has transitioned to medical malpractice because the patient has suffered some kind of discomfort or has suffered some kind of injury. It's inconceivable that a needle will be left in the womb or body of a person and there would be no injury. In fact, the reason why the person will report back to hospital is because something is going wrong. They're uncomfortable. And that will be classified as injury, for which compensation will be an appropriate remedy.
All right, well, the question I have then is, how does one prove medical negligence in a legal claim? This case, for example, it's obvious, because you say, we did an x-ray, we saw something is lying in there. It's the only way it could have gotten in there was during the surgery, you know, which I've had recently, and so therefore this could have been a result of that. But in other cases that are not so obvious, you go and unfortunately you went to see your wife off to deliver and she didn't come back. You suspect something, but it's just a suspicion. How do you prove?
So cool. You know, before I even answer the question, there's something I like to tell our listeners, or our viewers, actually. Now, when you go to the hospital, whether you go there for yourself or with somebody, you are at liberty, actually. It is your right to ask as many questions as possible to the doctors, nurses, what is happening to you. I think that's one way of picking information about the various procedures that you are going through. So that if something goes wrong, you know where to actually tackle, the matter from. Because I've said elsewhere, the getting evidence to establish a claim in medical negligence, as far as I see it, is not as simple as that. Now, there are, in other cases, you may be able to do that quite easily, but in the hospital, where most things do not pass through the patient's hands, for instance, and of late, where we have this cashless, we are going, electronic, cashless and everything, most things happen on a certain plane, right? And for instance, if we were to go and take a medical test and the test was given to you, some years ago, you would have been given, a physical document with the requesting for particular tests what you're going to do. Now, in the same hospital, it goes through a system. All you have to do is to go to the laboratory. And then you mention your name, they look at it, pull it out, and then do the test for you. So I'm saying that a lot of things are not passing through our hands anymore. And it's extremely difficult to, marshal the relevant evidence to prove a medical claim. And let me say that although sometimes in court, you may ask the court to order for those records to be brought, and be used in court and all that. But it's not as simple as that, okay? Because once the hospital has control over the documents, a lot of things can happen to those documents before it comes out, all right? And so, and I think Kelly, you have alluded to that. And when it comes to proof, the requirements for medical negligence or negligence are not different from all others. Now, as a plaintiff in a matter, you first of all have to establish your claim by bringing in the requisite evidence to establish the facts you are alleging as to their existence or their non-existence. All right. So the burden is on you, the one making the claim, but you have to get the right evidence. The thing is this: now, when you take the hospital on, and then you see the hospital, the standard you are going to require to prove that there was medical negligence is on the preponderance of the probabilities. Preponderance of the probabilities. Now, so I'm just imagining that in my 2 palms, the hospital is putting their evidence here, you are putting yours here. Yeah. At the end of the day, one must tilt in favor of the other. Yeah. Right? Yeah. And so you must get the right evidence. And so if you don't get that, it was going to be very, very difficult. And I'm saying that, but there are some cases where you may not even need, to do much. Okay. And I refer to the principle we refer to in law as res ipsa locuta, where we say that the evidence or the matter speaks for itself. Okay. And so, for instance, if I go to the hospital and I'm to go through a surgery, so I have a problem with the right leg or my right hand, and then I'm taken through anesthesis, I am gone. By the time I'm up, it's rather my left hand arm which is gone. The question I'm going to ask is, how did it happen? Yeah. Okay. Now, if my wife goes to the hospital and weeks later, an extraneous object is discovered in her system through an X-ray, where else could he have passed? Who else could have put it there? It could only have been through the experience with the hospital. So in those cases, it's really simple, but there are other locuta. But in other cases, it's not as simple as that. That's what I'm saying, that when you go to the hospital, you have a right to know what is going on. In fact, the hospital has a duty to inform you at every stage of the procedure you are going through. And failure to do that has its own legal implications and all that, but we should insist. And sometimes when you do this, people feel that, oh, you are a difficult patient and things like that. Sometimes they might even find a way to make you feel very bad about it, but you don't know what may happen. We've had cases in this country where people's wives have gone to the hospital and have never come back. They suspect that something went wrong, that a doctor should have done something, he did not do it, or he should have done something, he performed below the standard imposed on him by law. You need evidence to prove all those things. Like Kelly will always say, if you don't have the evidence, there's nothing else you can do. So,
Wow. Yeah. Well, I will take a quick break at this point. When we come back, we're going to get into further questions, tackling this issue of medical negligence. We'll be right back.
Citi TV is live on DSTV. Go to channel 363. On GoTV, access Citi TV on channel 182. On a digital TV, please press the menu button on the remote control and run a new search on your TV. Take note that without an antenna, you cannot access Citi TV on your television. Citi TV can be accessed on a free-to-air digital box like the GoTV and StarTimes box. Citi TV, it's your world.
All right, welcome back. It's still a question of law, and we're discussing medical negligence today. And it's a very interesting conversation that we're having here. Now, Albert had, made some very strong points on how does one prove, a claim that they have been negligent, the medical practice has been negligent towards him or her. But I wanted to find out if, Kelly, you have any thoughts on this.
Yes, I must admit that those of us who are members of the public, we actually face a lot of fearful odds when it comes to access to health delivery. Most of it is because of the attitude of our health professionals. I've heard a lot of anecdotal stories about how a doctor will not allow you to ask a question. In fact, if you were to walk into a doctor's consulting room and then you ask questions, the doctor will get upset at you. Yeah. That's something, you know, because all of us, if I want to go to a hospital, I want to do a little reading around my condition before I enter a doctor's consulting room, just so I can ask intelligent questions. But they don't encourage that. So that is a problem. But and I've undergone procedure in the United States before at the back of my head, and they took the time. It was as though the time between me and the medical doctor was even longer than the time taken for the procedure, because they encourage you to have a question to ask, you know, and things like. Unfortunately, in our part of the world is the opposite. And I think that our medical professionals have to be very careful, because any time a patient walks into your hospital, the theater, wherever, if you make any contact with him that he does not consent to, it amounts to another tort of battery. Again, unfortunately, in our part of the world, not many people know this. And so they walk into a doctor's consulting room, and then without warning, all kinds of contacts are made with their bodies. That can lead to actionable battery in most instances. So these are the problems that we face, members of the public who are assessing the health delivery system. But all is not lost. Albert has talked a lot about the difficulty in gathering evidence and things like that. Luckily, he's also told us about the principle of res ipsa loquitur, which is to say that the negligence speaks for itself. And in most of these cases, we can say that the negligence of the health professional actually speaks for itself. So then, procedural-wise, there is a reversal of rules. Where in case where the claimant has a burden to now prove the negligence, the particulars of the negligence on the part of the doctor or health facility. Now it's going to be the doctor or health facility proving that it was not negligent. And he gave a very fantastic example of somebody walking into a hospital. One leg is determined to be amputated. You agree to it, but you wake up only to find out the healthy leg rather is gone. Or as you discussed, a pain in the stomach. That matter was actually discussed in a famous Ghanaian case of Asante Cremo against the Attorney General. So I just want to encourage people who have these kinds of unfortunate encounters not to hesitate to go to a hospital. Sometimes the evidence accumulation or gathering can be very difficult, especially in these cases we talk about relevant evidence, not just evidence. And so we can fall on the services of experts, for instance, to come to court to offer their second opinion in cases where the doctor who is handling the case, the lawyer who is handling the case, or the patient is incapacitated from gathering the kind of evidence which will be required to lead to come, if you like, victory for him or her.
So if I let me just add to what Kikale just said, you know, and we experience these things, you know, in our daily lives all the time. You go to the hospital, things are happening, but you are afraid not to say. Sometimes when you go to the hospital, you fill out forms and you give indications of sometimes your profession and things like that. Especially when they see that you are in the middle class, you're somebody who is going to ask a lot of questions and all that. I mean, the attitude changes towards the patient. Look, if doctors or medical practitioners do not have anything to hide, if they are transparent in what they do, if they are reasonably competent as skilled people, I don't think that there's anything to worry about when people are asking you you know, questions. I've dealt with some doctors before. Not too bad. I mean, some of the doctors are really good. They take time to explain things to you. And sometimes you have a condition, but they make you feel like it's really not a condition and all that. And we need to encourage people to
but it's important that you added that. It's not all medical doctors in Ghana who do that.
But I've had occasion.
Medical doctors who will encourage you to ask questions and to speak.
I've actually had occasion to have conversations with persons from the medical fraternity and it appears that it's just probably the way we run our systems, right? And so typically you won't encounter a consultant at the first point of call. Okay. You're going to encounter maybe a houseman, you know, who's still trying to find their own feet. And so sometimes the questions can be a bit overwhelming and therefore annoying because I don't actually have an answer to this question that you're asking, you know, and so the pushback is you're asking too many questions.
Yes.
So, you know, just
but this boils down to our protocols for deployment of doctors at the hospitals. It would be interesting to find out whether it's appropriate, for instance, to send somebody to be on his own, a medical doctor to be on his own in a consulting room or theatre, when they don't have any experience at all. In those cases, shouldn't the protocol be that they should do the supervision of a more experienced medical doctor, you know, and if that doesn't happen, and this junior doctor conducts, you know, himself professionally in such a manner that leads to injury to a person, should that not amount to violation of protocols?
Okay.
And so therefore medical negligence, or as it may be appropriate, medical malpractice. And then these issues have to be interrogated.
Yes.
And it's important because I know that there are thousands of people who lose their lives because of medical negligence. It's happening all over the world. And I think that annually in the United States of America, about 250,000 people lose their lives through 250,000 people annually.
Yeah.
In fact, in the United States, it's the third highest cause of death in the United States of America.
Medical negligence.
Yes. And the reason we can never find out is because we don't have records.
Yes.
And there are many cases where the persons who are even victims don't go to report that they suffer this condition, their conditions aggravated because of the conduct of health. We'll never find out. More than likely, this could be about the second largest cause of death in our part of the world. If you look at the fact that in places like the United States of America, they have sophisticated treatment systems and machines, and to still think that in a year, annually, about 250,000.
You can imagine what's happening in our part of the world.
You can imagine what's happening here in our part of the world.
But so quickly, let me add. So, I just want to say. So when, people should be bold enough. Okay, when procedures are being done on your body, you should be interested. If you notice that something is going wrong, do not hesitate to talk to somebody. There's something I can imagine that, you know, getting experts to talk to can be really difficult. For instance, if you have a problem with the hospital, you want to probably talk to another medical doctor, you want to talk to a lawyer, things like that. And I know that sometimes costs and things can be prohibitive, but we should we should cultivate that culture of taking on some of these things when they happen in our hospitals. And I'm sure that there are a lot of people who are willing to help, you know, take up some of these matters.
If someone is going to have a successful claim, what are some of the basic things that need to be established to ensure that the claim is successful?
Yes, Koko, as I said early on, there are three things that have to be proved that the doctor or health facility owes to you a duty to be careful. The question of duty of care very much depends on foreseeability. So if you quickly or engage in a particular activity, if you can reasonably foresee that if you're not careful, that activity will lead to injury to a person or damage to the person's property, okay, then you need to be careful. You owe to the person a duty of care. So the concept of duty of care is not actually geographical.
Okay.
When we talk about neighborhood, you owe a duty of care to your neighbor. We're not talking in geographical terms. We're talking in legal terms.
In terms of proximity.
We're talking about legal proximity.
Okay.
In fact, that is why it's possible for a person to be here and then owe a duty of care to another person in Tamale.
Okay.
So if you engage in the production of sachet water, that will get transported from here to Tamale to be sold. You may be here physically, but you owe to a person in Tamale a duty to be careful. In fact, if you notice, that is why some car manufacturers would draw certain brands of their vehicles from the market across the world. Because it really doesn't matter that the manufacturing plant is in Canada.
Yeah.
You should reasonably foresee that these vehicles will be taken out to other continents and they'll be sold. And if there's a manufacturer's defect, these persons you owe to a duty to be careful.
Okay.
So, I mean, luckily, there will be no question about whether or not a doctor owes to a patient a duty of care.
That's one issue.
Because that has already been established. Then, owing a person a duty of care is not sufficient to ground liability. It's important that you prove that that duty has been breached.
Okay.
Which is to say that a medical doctor didn't conform to a certain acceptable standard, or didn't employ the skills and professional competence reasonably necessary for a person of his caliber or profession.
Okay.
Okay. So that's breach of duty. There cannot be actionable negligence if there is no finding of breach of duty.
Okay.
Again, as I explained earlier on, breaching that duty which you have identified doesn't, without more, lead to actionable negligence or a successful action in negligence. You ought to prove that there is injury. Not that there's just injury.
Okay.
That there's a sufficient nexus between the injury which the patient has suffered and the breach of duty by the medical doctor. Because it's possible for the patient to suffer injury, but that injury will have no nexus with the conduct or omission of the medical doctor.
Okay.
So we call that causation. So we're asking the question, was the medical doctor's action or omission the direct cause of injury to the patient?
Okay.
If it's not a direct cause of injury to the patient, then we say that there was no causation. Yes.
At other times, at other times, the causal link could be broken also by some other events.
Intervening factors.
Intervening factors.
So something did happen, but something else has happened that is unrelated.
Something else happens that actually results in the injury.
Okay.
You get it, and not the direct act of the medical practitioner. And so, I mean, these are things that we look at when we get to the courts eventually.
Yeah, so this is how to look at it. So, Kweku, a person goes to hospital. The medical doctor obviously was negligent.
Yes.
Perhaps administered the wrong drug, maybe antibiotic.
Yes.
And so it may lead to paralysis. It may not lead to paralysis of this patient. Okay, but this patient rather dies.
Okay.
So then the question becomes, what was the cause of death? The cause of death obviously is not the antibiotic which was wrongfully prescribed by the doctor. That wrong prescription remains just medical negligence. Okay. Because it hasn't transitioned into a situation where it is a direct cause of death for this person. Okay. But there's a principle we call, you take your victim as you find him. Sometimes a patient may be suffering from a certain condition that ordinarily can lead to his death. But the negligence of the medical doctor becomes a fillip, a catalyst for the death of this patient. Okay. It's okay to go to court and say, but this patient suffers from this condition. That could have ended his life. The court will tell you, you take your victim as you find him.
Okay.
Yes.
Now, I have a two-in-one question.
Okay.
first of all, talking about an intervening factor, is there a time frame within which a legal claim should be made? Otherwise, it becomes maybe null and void. You know.
Yes.
Okay.
And then what sort of damages can one ask for?
Okay. So if I get your question correctly, you're asking for whether there's a time frame within which somebody who has suffered an injury can bring an action in court. Definitely. I mean, you know, in this country we have the limitations decree, right? There's a law, Limitations Act, let me say it that way. I mean, that law provides for various causes of action or various fact situations, for instance, for which, you know, time is provided for you to go to court.
Okay.
So when it comes to simple contracts, for instance, the period within which you should go to court, from when you have become aware of some breach of the contract terms, is like is 6 years. I believe it's 6 years. And there are other claims which have specific time periods.
Yeah.
Okay. So I would imagine that when it comes to
more specifically, when it comes to negligence cases, it's 3 years.
3 years, okay.
So after 3 years, the cause of action becomes
extinguished.
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 Yes.
You cannot sue again.
Okay. And what sort of claims can one make if, in the case of you? No, so not claims, but what compensation, damages?
General damages.
Yeah. So the court to be minded to pay compensation. Often they pay compensation according first to the amount of money you have expended on treatment and things like that. The court will award you compensation for the pain that you have undergone. Sometimes medical negligence can lead to permanent disabilities. The court will factor that into determining how much money you should be paid. Sometimes permanent disfigurement. If you recall the June 15 disaster, the flood victims.
Is it May 3rd?
June 3rd.
2015.
June 3rd.
2015.
Yes, 2015.
Flood disaster.
And you should see some of the victims. They've suffered different kinds of disfigurement, some of which are very permanent. One who told me that when I went home, my kids were running away from me. You know, so the court will take all of those kinds of things into account and determining how much compensation a person should be paid. Unfortunately, in our part of the world, our judges don't award sufficient compensation for very egregious violations of the bodily integrity of people in Ghana. Our courts often will offer you something very little. That if you were some places like the United States of America or the UK, you would be salted for the rest of your lives. So that's one of the things that I think that our justice delivery system has to improve upon. There are persons who go to hospital, they paralyzed ways down because of the negligence of a health facility or a medical doctor. But all what they get is 250,000 Ghana cedis.
It's unfortunate. You know. Well, this has been a very interesting conversation. Don't go anywhere. We'll take a quick break. Up next is the docket.
Citi TV is live on DSTV. Go to channel 363. On GoTV, access Citi TV on channel 182. On a digital TV, please press the menu button on the remote control and run a new search on your TV. Take note that without an antenna, you cannot access Citi TV on your television. Citi TV can be accessed on a free-to-air digital box like the GoTV and StarTimes box. Citi TV, it's your world.
All All right, welcome back. It's the docket, and today on the docket, I have a very interesting one here. It says, I ordered food from a restaurant using a food delivery app. Now, unfortunately, when the food arrived, I discovered that the fish in the soup was spoiled. And I realized this after consuming a few spoonfuls. I was extremely frustrated and upset by this incident, and now I'm considering taking legal action. I would like to know who is responsible for this situation. Is it the food delivery app or the restaurant? Additionally, I want to mention that the food delivery app assured the quality and integrity of the food items on their platform. Please provide me with guidance on how to proceed on this matter. How can the law help me?
Okay, cool.
Yeah.
Well, I picked up one thing from what you read.
Okay.
She says she's what? Upset.
Yes.
Is that
Frustrated.
all? Frustrated.
Yeah.
I mean, that's not enough to ground the real cause of action.
She didn't get any food poisoning.
She didn't get any food poisoning.
It's just that she tasted the thing was bitter.
Upset or any problem for that matter. But definitely, if you want to take up such claims, you must show that there is something, you have suffered something. You get it. And sometimes it could be the trauma of knowing that you have eaten rotten fish.
Yeah.
I mean, sometimes it can stay with you for a long time. If you have experienced that before, the thinking that you have eaten something which is rotten, which is unwholesome, you know, it can have psychological, and I don't know whether maybe Kelly will talk about the possibility of, you know, staking a claim for psychological, you know, situations, maybe when he has his day. But I think that this, you know, first of all, I don't really know how this food delivery app is working, but it looks like somebody orders food from a restaurant, and somebody else is supposed to pick up the food and deliver it. If that's how it's working, so levels of contract.
So typically the app
has
its riders.
Okay.
Right.
And the app is also the one, the app company is selling the food?
No.
Okay, they are not.
They are only going to pick up the food and deliver to you.
Okay.
So the app delivery company, the food delivery app, is the intermediary between the restaurant and you.
Okay.
That's literally what's happening.
All right, so that's what it is. So, I mean, I'm sure that when you order food, you'll probably be told when the food will be delivered to you. And so if the food is ordered from the restaurant, and at the time the delivery guys were picking the food was in a good state, right? We don't even know how we can prove that, but at least once we were picking the food, if the food was in a good state and went bad along the way, we have to find out at what point the food went bad. Is it a case that the delivery company, when they picked up the food, they did other rounds and caused delay, so the food went bad along the way? I mean, these are matters which require some form of further questioning and the receipt of answers, and so it can be at two levels. If the restaurant actually gave the food in a wholesome condition, then they should be absorbed in the circumstances. But if the food itself, at the time it was picked up by the delivery company, we can show that it already had a problem, then the restaurant should take responsibility for that. So I see this from this angle. Definitely one of the two are responsible, or is responsible for the problem the food is having. Is that the restaurant didn't cook the thing well, or there's a problem, or the delivery company, delivery company
somebody
didn't do the
delivery and
when the food went bad. So these are matters that we have to investigate and establish. Once we are able to find the real culprit, or the one who actually is the source of the spoiled fish, then it raises issues of breach of contract and other matters.
Especially that the app also promises that the food will be in a certain pristine condition when it arrives. And
it can also raise other statutory offenses, like selling unwholesome food. It's criminal to put for sale food which is spoiled and all that. So I mean, we can say at this level that our good friend has some course of action, but we need some background questioning. We need to know which app he or she dealt with, and the timelines within which the order was placed and delivered and all that. Once we know this, we can properly frame a course of action and decide who to go against in the circumstances.
Well, unless of course there's been some agreement between the food delivery company and the makers of the food, that when you pick up the food from my end, you should make sure they deliver within a certain time frame. Because this kind of food will begin to go bad after an hour. So it has to be delivered within a certain time frame. I don't see why a food delivery company should give an assurance about the quality.
I find it very bizarre. Because you're not cooking the food.
Silly thing.
Yeah, you're not cooking the food.
Very silly thing to do. Yes, it's a very silly thing to do. Again, this is what happens when a lot of people are not consulting lawyers as they enter into these kinds of contracts. You're encouraged to consult a lawyer when you're entering into any kind of contract, because it will protect you.
Food delivery.
Absolutely.
Yeah, because I think that it's an overreach.
Yes.
To say that we promise you that the food will be in pristine condition, and the quality of the food will be top notch. Meanwhile, you didn't cook the food.
Yes. Absolutely.
You're only picking and dropping it off.
It's a very silly thing to do. And Albert talked about whether or not a course of action can be sustained, especially when the person is just complaining about being upset.
Yeah, I know. Right?
The common law doesn't compensate for injured emotions and things like that. So it ought to be some substantive injury which this person has suffered. But we need to retire the idea of perceiving injury in terms of somebody falling sick, or somebody's body having been lacerated or having lost a limb. In fact, the common law offers equal protection for what do you call it, psychiatric injuries, which are not visible on the surface, so to speak. And so if you ate the food and you felt nauseous and things like that, that's some kind of injury that can be compensated for. You talk about somebody having even panic attacks. Did I really eat this food? And then you wonder what's going to happen to you. Every now and again, when you remember you feel something. That's some kind of psychiatric injury that can be compensated for. I think that's a little I have to ask.
Yes, because let me just ask you just a quick one. Do you think that we can apply the manufacturer's liability principle to this one? This is not.
No, so the maker of the food.
The maker of the food
is the manufacturer in this sense. And so those principles apply to how they made the food. And they kind of,
So when you are a maker of food, you have to be sure that the food is in a state
that if your customers eat it, they will not suffer from any kind of injury.
All right, fantastic. Well, thank you for that education there. Well, it's time for our legal trivia today.
Legal trivia. Did you know where a public officer declares his assets before the assumption of office and subsequently acquires any property or asset which is not reasonably attributable to his income, gift, loan, inheritance, or reasonable resource, those extra properties acquired shall be deemed to have been acquired illegally. This can be found in Article 286(4) of the Constitution of Ghana, 1992. Take note and do the needful.
All right, so that was the legal trivia for today. And that's it for the conversation today on medical negligence. Very interesting conversation that we've had. And don't hesitate to seek legal advice, when you come across any of these challenges. Don't wait till it becomes a huge problem. If you have any questions at all, just reach out and, get get legal advice as to what to do in these kinds of situations. A big thank you to my guest today, Kwesi Kelly Delata, who's a legal private practitioner, as well as Albert Kwashiga, also a private legal practitioner and a law lecturer with the UPSA School of Law. This has been a question of law today. My name is David Kwekusechi. Keep watching Citi TV.